Hello and welcome to the daily newspaper analysis, an initiative of the UPSConline.com and Ambition IS. Today we shall be discussing the newspaper of the 30th of December 2017. So coming to the first article, Lured by Blood Money. This is a ground cover report on the editorial page of the Hindu, and for many readers and many students this might not be an important article, but the article has immense importance from ethics point of view, because it has a number of ethical concerns and ethical issues that have been raised in this article. Also, I'm expecting a question. This is an important topic. A question can come in the ethics paper, either in the theory part or as a case study. So I have divided this article in the context of this article and the issues and the suggestions that have been given in this article. There are a number of stories and the case studies that have been given, which I shall not be mentioning in this, but rather extracting the relevant points. So that's how I have covered this article. Now coming to the context of this article, the context is that of bioequivalence studies and bioethics. Now, what do you understand by bioequivalence studies? Bioequivalence studies are the studies that are conducted on people. They are conducted as clinical trials for drugs on living volunteers. That is what bioequivalence studies are. So, in such studies, definitely some ethical questions are raised. And the article is based on the idea of people who are over volunteering for clinical trials in order to supplement their income, therefore risking their health, especially in the case of serial volunteers. So that is the context of this article. Now, many ethical issues have been raised. These issues I shall be discussing now. The issues are that first and foremost, money is being paid. Now, how can you fix the sum that is going to be paid for life of an individual? This is an ethical issue. Can life be monetarily valued, and if yes, then how much? That is a question. Also, the money that is being paid in this case is a mere, it's not even a remuneration. Rather, it is a mere pittance allowance that is given for the loss of work that these people are facing due to coming for clinical trials. On those basis, this money is being paid to these people. So it is largely a matter of exploitation of the people, as they are not being paid according to their work. So that is the first issue. The second issue is that of liability of companies conducting trials. Now, what is happening is that in many cases, the volunteers who are undergoing these trials suffer various health issues. In worse scenarios, they have even suffered death due to these trials. In such a scenario, what is the liability of the company? That is questionable, because the companies are not being responsible to the family of these people after their death, or for that matter are not being even held responsible for their death. So that is one issue. Some regulation needs to be made that how liability can be fixed on the companies. That is another thing. The third very important ethical issue is an issue of informed consent. Now, whenever this idea of an informed consent comes in ethics paper, you have to understand the whole basis of informed consent is that a person should know whether or not what will be the consequences of this informed consent. Now, for example, in the past I had read a case, I had heard of a case where an informed consent was signed over a surrogate mother, and when the child was born, the surrogate mother refused to give the child to the parent. So she was sent for trial in a court, where the parents of the child had claimed that because she had signed an informed consent previously, she is supposed to return the child back. But in that case, what had happened was the court had ruled that the mother was never aware. Before the child was born, she couldn't decide, she couldn't be informed that how she would feel after she was a mother. In such a scenario, the consent is really not an informed consent, rather a mere hoax. So that situation is valid here also. Are people educated enough to know what are the outcomes of these trials? Are they, empowered enough to understand the risks that they are taking? So that is the entire idea of informed consent here, that the consent is definitely being signed by these companies, but its relevance is questionable in this case. So that is an ethical issue. Another issue is that there is no consent from family members of the person who's volunteering. This is a major loophole, because in many cases the person who's volunteering is also the sole family owner of the family. So in such a scenario, the lives of the family members is also going to get impacted, and so their consent is also mandatory. This is an ethical issue that has been raised in this article. Also, there is no effort made to verify the facts by these companies of regarding facts regarding these volunteers, regarding their age, regarding their habits. They just simply they are accepting what the volunteer is saying, and this the article brings out is a major flaw in volunteering process, because many a times the person who is volunteering is above the age. So those kind of situations are there that company is not being held responsible for verifying those facts. Also, this not only threatens the life but raises questions on the utility of tests itself. Why? Because if suppose the test is supposed to be conducted on a person who is non-alcoholic, and the person says that he's not consuming alcohol, but actually the person is secretly consuming alcohol, in such a scenario the test in itself becomes void, because the exact clinical conditions are not being met. So what is the purpose of playing with the health of a person if the test is also not going to be achieved? So that is another issue. Also, volunteers are largely from financially weak strata of the society. And that is why a question is being raised, that are they getting coerced and exploited and are highly vulnerable? See, if volunteering is happening all over the society, definitely science has to grow. Medicines have to be tested. We cannot deny that this science of bioequivalence should altogether be done away with. Definitely not, because this is something in the interest of the society. But a pattern is being observed that volunteers are largely volunteering for the need of pittance allowance that they are getting. And that is what is the responsibility of any state, to protect its vulnerable. So that is an ethical concern over here. Another thing is that of a government vacuum in the case of death of the volunteer, as there is a poor investigation system. There are cases mentioned here that when the volunteer died, there was not even a post-mortem conducted on the volunteer's body. So these kind of things are somehow a reflection of the need for proper codification of laws, proper regulation and proper investigation of such issues. So that's important. Also, there is no method of grading of risks in different trials, because all drugs are different. For example, a drug which is a new form of antibiotic will have a different impact on the body as compared to an anti-cancer drug. For that matter, a drug for a skin disease will be different. So these kind of grading is not done of all drugs. Rather, people are volunteering for all trials without any knowledge of the degree of risk associated with the particular drug. So a proper grading system should be done, and not only that, an information should be given to the volunteer regarding the risks involved with each and every drug. That is another issue. Also, in this scenario, the lure is not of social service, or for that matter, seeing the relevance of drug. The lure is that of money. And this is the biggest threat for a country, especially like India, which has a large section of its population vulnerable and poor. So that is another issue. Also, this has become a bustling marketplace. The entire process of bioequivalence has become a marketplace where WhatsApp groups are being formed and ads are being given on WhatsApp groups and social media platforms. So this is something again which reflects that it is not under the regulation of the government and outside the view of the government. So this is one important ethical issue again. Even the term that is used here, blood money, is actually a WhatsApp group which is functioning for bioequivalence studies. So those are the ethical issues. Now there are some good suggestions that have been offered. Another issue, which I would like to add is that this process of clinical trials in India is something very secretive. It is not happening openly. Why? Because this is a cultural taboo in the country. So the stigma associated with undergoing trial needs to be removed, so that even if a person is volunteering, he should be open about it, and he should discuss it openly with his family. He should maintain his documents. There are many cases where people are even throwing away their documents related to the tests that they have undergone, for the simple reason of avoiding social stigma and outcasting by the society. So that is one important issue again. Now the suggestions are: first and foremost, there should be proper dissemination of information, including the health risks and side effects of all the clinical trials. Examples. Now, these are some good examples that have been mentioned in the article. The examples are: by meeting the participants and administering questionnaires to gauge their awareness levels is something that is important and should be done. Also, countries like the UK and France have a national registry of volunteers. Now, this is not something that is a process in India. Even if not at the national level, we can have these national registries at state levels, or for that matter at district levels. But some amount of data by the government on volunteers should be maintained. That is a good suggestion. Another thing is that social campaigns to improve awareness and remove the stigma associated with clinical trials is something that should happen. So those are the issues and suggestions that are relevant. Coming to the next article, taking on the gatekeepers. Now, the opinion that the author has given is that as long as courts affirm community claims, don't expect the censor board to protect free speech. Now, the context of this article is the recent CBFC's announcement that a 6-member panel will be constituted to review the movie Padmavati. And this panel, the 6-member panel, shall include historians, it shall include representations of the royal family members of Mewar. So that is the context of this article. Now, coming to some background. Now, the Central Board for Film Certification, in short the CBFC, has been formed under the Cinematography Act of 1952. This was the norm. At that time, the reason for this was that films shouldn't be released without any certificate by the government. So that was the entire background, and this body, the CBFC, is responsible for certification. It is the Central Board for Film Certification and not the Central Board for Film Censoring. So there is a difference between certification and censoring. That is the prime debatable issue and prime contentious issue in this case, that when this is a certifying body, why is it censoring the films? Its only duty should be to recognize whether a film is appropriate for a particular age group or not, and depending on that it should issue a certificate. But here not only that is being done, rather censoring is being done. Producers and directors are being asked to cut particular scenes and all. So those things are something that is questionable in a society where freedom to speech and expression is a major fundamental right. So that is the entire context of this article. Now, some good issues have been raised by the author in this article. From that point of view, this article is of immense importance. Now, the first issue is that what a historian is supposed to do in a panel of film examining or film reviewing, because this film is not a film, it's not a historical documentary, rather it's a historical fiction. So if this is a fiction only, then what is the role of historians? Another thing is that how come the royal family of Mewar assume a veto power in a democracy? That is another pertinent question. Also, this is a scrutiny. The authors use a good keyword where he says that this is a scrutiny akin to something like a self-appointed community gatekeepers. So that is important, that in a democracy, nobody is, liable to, it's a rule of law. So how can a family assume that role? So that is important. Another thing is that this is a legal and a constitutional matter and not a sentimental and a popular one. So why is it being treated as a sentimental issue? Another thing is that issue of that in order to qualify for constitutional protection, which is a person's right, an individual's right under fundamental right, should a piece of work qualify as a work of some social value? For example, should every movie have something of a scientific knowledge or a historical knowledge or inculcating patriotic values or advocating good social habits? Only then a movie is liable to be released. And otherwise, if an artist has a different opinion and he wants to criticize maybe the government, in that case, shouldn't he have the right to express his creativity? That is a major issue that has been raised in this article. Another thing is that if an artwork is related to a segment of society, then does that segment acquire the right to decide whether or not it has been offended? This is a trend of rising intolerance, and I'm really expecting analysis on intolerance and UPSC mains, because this is something that is very pertinent in the society at present. Similar cases have been seen previously also with movies related to Udta Punjab and Jolly LLB. In the movie Jolly LLB, there were claims that lawyers, it's a movie against the lawyers, and it disrespects the lawyers. So the Bombay High Court had set up a reviewing committee of lawyers to watch this movie and then pass this movie. Now the question is that who are lawyers to decide that this movie should be released or not? It's a particular community in this society, definitely, but does not mean that they should decide for all the citizens of the society as a whole. So that is one good question that has been raised here. Also, the author brings about a very important issue is that such behavior of the CBFC and such conduct in the society is something that is being sanctioned by the courts time and again. For example, previously, like I mentioned, the Bombay High Court, even the Supreme Court has banned books saying that it is not good for a society which is so diverse. So that those kind of things are being raised. Also, going back to the pre-constitution era where communities were more important than individuals. However, in the modern time, the constitution, definitely we all know that the heart of the constitution is an individual rights rather than community rights. So why should communities as specifically be given precedence over individual rights? So that is one very good issue that has been raised. Also, the issue is that there should be focus on inculcating tolerance in the society, which has been completely lost, and the focus is shifted at imposing bans on the freedom of expression and at regulating art in the society rather than creating acceptance and tolerance amongst the citizens. So that is one thing. Also, the issue of art as an art or a useful art is something that is important. This you have to understand. Now, art is something that is creativity and expression or of an individual, but rather it should never be something that is always bound to be as a useful art. And even if it is something under the ambit of useful art only, who is going to decide whether it is useful or not? There's a lot of subjectivity in this matter. A good case has been mentioned here of the movie Bandit Queen, where some sexually violent scenes were there in the movie, and it was decided that these scenes are good because the art here represents it will create a disgust in the minds of the viewers against sexual violence. So that was considered good. Now this clearly reflects that how much subjectivity can be brought up in such kind of cases of related to art. So this is a very good point again. Also, some suggestions have been given by the author, only not many suggestions, but rather one of the core suggestions that he has given is that the courts need to come out as the guardian of freedom of speech, which he says that until and unless the courts, who are the guardian of the constitution and the fundamental rights of the citizens, until and unless the courts take a proactive stand, probably such kind of intolerant activities shall not be subsided. So it is the courts who have to lead, and so he gives a good suggestion that from bottom to top there has to be a change in the mindset. So that's about this article. Coming to the next article, a necessary reform. The article is based on the concept of conflict of interest, especially in the case of bureaucrats after their post-retirement avenues. So that is the context of this article. We all know that now life expectancy in India is increasing. So the retirement age of 58 or 60 is not a very high age. And many a times post their retirements, bureaucrats, you want to use their expertise and experience and they want to join the corporate sector. But this definitely leads to something called a conflict of interest as, their decision to join a particular corporate after the retirement or for that matter even after the resignation can guide them to have certain biases during their service. So that is the context of this article. The author has given an opinion that there is a need to remove discretion and codify rules relating to conflict of interest. That is the opinion. Now coming to the issues that have been raised in this article. The first issue is that there is an issue of corruption because of conflict of interest. As I clearly said, that the bureaucrats, or for that matter, even other wings of governance like judiciary as well as the legislatures themselves, they can have some malified intentions in order to benefit their post-retirement avenues. Like recently, even the Chief Justice had mentioned that he wants to it would be better if we allow our judges to practice after retirement, because judges are retiring at 65 and he says that 65 is the prime age for any lawyer. So that is another case. So if a judge is allowed to practice post-retirement, then he can be biased towards some corporates who are offering him good cases post his retirement. So such kind of situations are there. That is the first issue. Also, the second issue is that there is something called a cooling off period. I'm sure you all have heard of this. Now, this period is after their retirement. Every officer is expected to go into a cooling off period where he is not allowed to join any corporate sector job. However, this cooling off period is a loose one because If a bureaucrat writes to the Ministry of Personnel requesting for being given a waiver from the cooling off period and wants to join a corporate, in such a scenario, it is a pure discretion of the government to whether or not allow this, diversion from the cooling period. So the author here brings about a point that this discretion should be done away with, and proper codification of rules and laws should be made as per which the cooling off period shall be mandated. That is one thing. Another point is that there should be no problem in letting experienced bureaucrats utilize their experience and expertise. This is a good conduct, but provided it does not generate a conflict of interest. So that is the opinion that the author has. Now, beyond these issues, he has given some good suggestions that what can be done to do away with this conflict of interest. These suggestions are that making non-disclosure of interest a punishable offense. Every bureaucrat should clearly spell out his conflict of interest in case of any appointment, even in the government as well as when he's joining the corporate job. That is one thing that the author has suggested. Also, he says that increasing mandatory cooling off period to 5 years, because there is no mandatory cooling off period. It has a discretion. Also, extending this code to all arms of the government, like I had mentioned before, also legislatures, executive, as well as the judiciary. Further, he says that more transparency should be brought about. This is important in the GS paper too, from the transparency and accountability point of view. The conflict of interest is important from the ethical point of view. So yeah, he talks upon bringing more transparency through an open public data platform in listing all post-retirement appointments of civil servants. So, that is what the author has suggested. Coming to the next article. This is an article on the recent Mumbai fire tragedy. The context is that 14 lives have been lost in a fire in Mumbai rooftop restaurant. So there is a need, definitely. The opinion is that there is a need for a relentless campaign for safety of buildings. This is what the author has suggested. Now, coming to some good issues that have been brought about in this article. The first issue is that accountability of the owners, the managers, and the official agencies is something that should definitely be done in the aftermath of this disaster. Now, the Mumbai fire tragedy is something under disaster management only. Not only that, it is under corruption also. It is under so many other topics. It is under, these urban arenas and urban buildings like that. Many topics are there under this. And it can be used in many various opportunities. So that is the importance of this article. So the first issue is that of accountability of the guilty. Also, he says that there should be punishment of the guilty. A stringent punishment should be given. Exemplary compensation for the family of the dead and the injured. Also, there should be zero tolerance enforcement of the safety requirements of buildings, which is not happening in India despite so many episodes of fire. That is a very good point that the author has brought about. Also, he says that there are no lessons learned from the Upar Cinema Hall fire in New Delhi, which was held in 1997. And he says that, in that case, what had happened was that the exits in the theatre were blocked because of indiscriminate seating arrangements and irregular seating arrangement in the theatre. So some lesson should be learned, because a fire tragedy is not a mere negligence. It is rather something that is a flouting of the rules and laws. On the business, the building and construction, norms have been flouted here. So that is what the author is trying to bring about. Also, he says that it is wrong to categorize deliberate acts of negligence into mere accidents and that kind of mere washing away this episode as an accident. That should not happen this time. He also says that in-depth inquiry with a public report followed by meticulous prosecution is the only solution to this tragedy. Further, he says that there is an issue of an absence of a strong law of torts. Also, this is accompanied by a slow criminal justice process, and rampant bureaucratic and political corruption have contributed to the brazen violation of building norms in India. So all of this is not a mere mistake of the management there. It is a complex issue. The judiciary needs to fasten up in case of trials of such cases. The investigation needs to be more, rigid. Also, the building norms need to be more stringent. So it is a complete process. That is what the author has brought about. Also, the issue of regulating illegal construction by politicians during elections is something very important. I've mentioned this previously also. Even in case of earthquakes, this becomes important. In case of all disasters, this thing is important. That because irregular colonies are being regularized by politicians as a part of their election campaigns, this is the biggest threat to urban governance, because sometimes these colonies do not even have the passage for a ambulance to pass through, or for that matter, in this case, of a fire van to pass through. So in such a scenario, this is a major complex issue. Also, if such irregular colonies are regularized, then they become mere death traps, and today or tomorrow, an accident is going to happen there. So that is what the authors brought about. Also, the court orders issued to ensure public safety remain mostly on paper, and this the court needs to take into consideration. Even orders relating to public safety on roads is something that is not being very blatantly is something that is blatantly ignored by the government. So that is one issue. Also, the issue is that of the value of lives of Indian citizens, which seems to be losing its importance in this country, because many a times these episodes have happened, and repeated ignoring of lessons from these disasters is something that is a major cause of concern for the citizens and the country as a whole. So that is what this article brings about. With this, we finish today's discussion. I thank you all for watching this video. I hope you'll recommend it to your friends, and we shall be expecting your feedback. So hope to see you tomorrow. Thank you.